Mark Meadows, co-defendant in a prosecution against Donald Trump, has successfully gotten his removal request scheduled in federal courts. Good news. We know that Trump, Meadows, Giuliani, and many others are being prosecuted by Big Fani Willis out of Georgia. State court. Question is, can Trump, Meadows, Giuliani, and others remove the case from state court up into federal court so they've got a better jurisdiction? They've got a federal judge rather than a state judge. So this becomes a federal case, not a state claim, and arguably Trump could get a better judge. You could say it's a federal claim now. Maybe Trump can walk right in and pardon himself from this. All sorts of different tactics that this could go and different routes this could go. But let's take a look at the order from the judge. This is what the court has ruled, and we expect ourselves to see a similar filing from Donald Trump. It's 11 pages. The matter appears before the court following Mark Meadows' notice of removal under that statute, 28 U.S. Code 1442. The court enters the order following, look, the satisfaction of the statutory requirements for state criminal prosecutions being removed. The court says, in summary, that the summary remand is not required. In other words, this case can stay here for the meantime. Remember, we've gone through this once before here. Donald Trump tried the same thing in the Alvin Bragg prosecution out of New York. He said, I was running for president. The New York allegations stem from my conduct that was running for president. Therefore, it's a federal issue. I was a federal officer. It should be removed. The court just said no. We didn't have a hearing. We didn't have anything. The judge just wrote a motion. Nope, rejected. I don't find that you were in office of the presidency at the time, or this was contemplated for that purpose, these loans or these payments over to Cohen, and so rejected it. We are past that hurdle now. We are now in federal court. They say, on August 14th, the grand jury, Fulton County, returned an indictment against Meadows. 18 other co-defendants, of course, Trump is included. The indictment says Meadows and his actions related to Georgia violated Georgia criminal statutes. Meadows served as the White House chief of staff under Trump for a while. He's now included in a RICO claim. It alleges the following as predicate acts in support of RICO. One, that he met with Trump and Michigan officials. Another one, he messaged a representative. He and John McKenty put together a memo that they say is disrupting or delaying Congress. He was trying to observe in Georgia and was physically prohibited from observing. He arranged a phone call between Trump and investigator in Georgia, Francis Watson. He messaged an investigator. He solicited, along with Trump, Brad Raffensperger. They say to violate his oath, right? This is from Big Fani's claim. And so on. The indictment further charges that Meadows solicited a violation of public oath. They say, all right, Meadows filed this removal to the federal court. He says federal jurisdiction exists because I'm a federal officer. My official duties were arranging meetings, communicating with state lawmakers, and I attempted to go audit Georgia's election so I could report to the president as the chief of staff. With the background in mind, the court says, the court now determines, we ask ourselves, now that we know all this, whether it clearly lacks jurisdiction over this case and whether this case has to be booted back down to the state court. The feds keep it, or is this for the Fannies? And again, this is not a final determination. This is only to schedule a hearing to make arguments on this case, because Fani, we haven't heard from Fani yet. She hasn't submitted anything. Mark Meadows submitted this, and so on its face, they say, all right, Mark, you make a convincing argument. So now we're going to have Fani come in and say, no, this is why it has to go back down. But we never got there in New York. So the legal standards, they say federal courts are courts of limited jurisdiction, only the power authorized by statute. One statute says the following. Analysis, they say, according to all those rules, the court first determines that Meadows' removal does meet the requirements of the law. Here's why. Meadows removed this action one day after the indictment, so he didn't wait too long. Timing requirements have been met. The removal contains the grounds for removal, the basis for federal jurisdiction, and so he checked the other boxes. The court now, we must look at whether the removal filed, if it clearly appears that the removal should not be permitted. Is there anything that says it should not come in? They say here, the court determines that the notice of removal and the attached indictment, so Mark's filing and the indictment, are sufficient to show that summary remand, a rejection, is not clearly required. In other words, it is not immediately apparent on the face of the documents that we must reject this. The notice of removal indicates that Meadows held the role of the chief of staff for a while. It also submits he was acting in his capacity when all of the criminal allegations occurred. He asserts that his defense to these criminal charges arise under federal law and under the Supremacy Clause of the federal Constitution. So accordingly, the federal court determines that Meadows' notice of removal is sufficient to withstand the remand. The court emphasizes that this order offers no opinion on the court's ultimate determination on this. You're not saying whether he's immune or not. Just say that the court is going to make its final determination on these matters once it's been completely argued, once these matters are briefed and ripe for the court's review. If he's going to say, I've got federal immunity here, we need a federal court to deal with this. So to reiterate, the judge is being very clear. This order's limited conclusion is that the court, based solely ruling on the facts here does not clearly lack subject matter jurisdiction over this, and therefore the court will proceed with an evidentiary hearing pursuant to the code, going to the next step, which is good. Like, you can expect to see other defendants who were federal officials file this. In conclusion, they say, for the foregoing reasons, the court concludes that the face of the notice removal do not clearly that we have to reject this, no opinion about the other defenses, so therefore we order that the parties participate, including Big Fani. You got to show up to federal court concerning the notice of removal of the indictment against Mark Meadows. So get your butt over there, prosecutor. Monday, August 28th, 10 a.m., courtroom 1907, Atlanta, Georgia. The court orders that defendant Meadows immediately serve the Fulton District Attorney Fani with a copy of this notice and a copy of this order. So now Meadows is doing the serving. How's that feel, Fani? She may submit a written response to this or show up in court. If she wants to challenge this, August 23rd, and her response must be no longer than 25 pages. Signed by the Honorable Steve C. Jones. So that's very interesting news. So Big Fani's going to have to show up there and respond to this. Now, you notice something, that they said that they needed to serve her with a copy of this so that she knows to appear. But something interesting happened. Mark Meadows and his team, they filed a notice regarding service. This is weird. Why would they have to file this? Shouldn't they just serve her and just say, here's our affidavit of service? What's the notice about? Let's read. It says, hey, Mark Meadows, by his lawyer, hereby provides notice regarding compliance with your order to serve Big Fani with this. Pursuant to the order, I mean, she's got an office. She's like in Georgia, like just walking into the office and serve her with the document. How hard can this be? She's the biggest Fani in Georgia, literally. She's the district attorney of Fulton County. Huge, can't miss her. Pursuant to the order, Mark Meadows and the lawyers attempted personal service of the notice of removal and the order on Fulton County District Attorney's office earlier the day. That's Willis's office. However, Meadows' process server was told by the receptionist that there was no one in the office that can accept service and to try back on Monday. What? Big Fani won't even accept service from a federal court at her in a case that she's working on? I mean, from one of her defendants. This is Mark Meadows, a defendant in her case, showed up to the county office. So they say that they're rejecting our service, judge. I don't know what they're doing. Just let you know. In light of the foregoing, this afternoon, we sent an email to Big Fani and to Deputy Fulton County District Attorney Wooten, who had also entered an appearance in this action earlier on the day. We attached the notice of the order and we request that their office accept service via email. As of the time of this filing, Mark Meadows has not received any response to this request. And defendant will attempt personal service again tomorrow and continue his best efforts to effectuate service on Big Fani Willis. Why is she hiding? What's she hiding from? Defendant also notes that despite having yet to been unable to personally serve the order, the Fulton County DA's office has already received notice of this action and the upcoming hearing. In addition to the email sent by our lawyers earlier today, counsel previously provided notice of this removal action to Willis, Wooten, and 3 other attorneys via email back a few days ago. Ms. Willis promptly responded to this email, confirming that the email from Meadows' attorney was received. We know Willis was listed as the attorney of record on the docket and received the notice as well from ECF, which is electronic court filing. Submitted by counsel for Mark Meadows, Joseph Englert, out of Atlanta, Georgia. Shout out to Joseph Englert. August 17, 2018. What's going on there with Big Fani? What's she running away from? Oh, she's got a notice. She's got an order to be served from a federal court, and she's hiding from it. Very strange. Now, something else is interesting here. So there was another filing from the Meadows defense team, and they're holding firm to this August date. They say, Your Honor, earlier today, Meadows in our defense, we know that counsel for another defendant that is named as a co-defendant in Georgia, he informed the court by email, and I don't know who this is, that he intends to file a forthcoming notice of removal as well. So this judge is saying, oh, we're going to have, there's 18, 19 co-defendants here, so might have more of these. And they suggested via email that they postpone Mark Meadows' hearing. Okay, Mark Meadows has his hearing on the 28th. They're saying we better consolidate all of these removal requests and let's just do it together. But Meadows says, no. How about no? Meadows opposes any delay of the August 28th hearing. As this court has noted, Mr. Meadows has a right to prompt hearing under the removal statute, and we've scheduled the hearing accordingly. Moreover, Mr. Meadows has articulated grounds for seeking removal unique to Mr. Meadows. It should be considered unencumbered by different issues potentially raised by different defendants. So they can make their claim, but don't batch us and lump us up with them. Accordingly, Mr. Meadows respectfully submits that the court hearing should proceed as planned. Signed again by Joseph Engler. And this is going to be interesting. And we've got all these different co-defendants all crashing into one another, and the courts are going to have to untangle them. Big Fani got the whole thing just jumbled up. It's a messy ball of yarn. Now, John Ratcliffe, who used to be Trump's director of national intelligence, had some comments about this. He says, all said and done, what we see here is this is just an operation to go after Trump. All said and done. They've been working on this for years. Here it is.
Well, Maria, I don't think it's that they're ignoring it. I think it's that they're scared. Look, you have to keep in mind that they're all co-conspirators in this. They're all complicit in this.
Talking about
what I mean by that is all of this stuff. It was the fact that the mainstream media went with all of the things like the Hunter Biden laptop as Russian disinformation. They promoted the 51 intelligence officials that were lying. They promoted the Russia collusion story. All of these things, and folks at the Department of Justice and the FBI, they lied to get FISA warrants to spy on the Trump campaign. So they're all, they were all part of this, and they're all complicit in this, and there's so much at stake. And if it unravels, it's not just political folks that will take a fall on this. It's the American people will see it for what it is. Now, so having said that, these are the challenges that President Trump continues to face. With these charges and the trial dates that are coming up. The thing that I would point out to people here is that Donald Trump didn't run for president run for re-election as president to avoid political charges, as some people are saying. You got to remember, he announced he was a candidate first. He became the front runner first. All of these charges in Georgia, in New York, both Jack Smith cases and the federal cases, they decided to bring charges after Donald Trump became the leading contender in the Republican nomination, which just really underscores why this all continues to be political and why it's all directed at trying to stop him from being reelected.
Yeah, we often forget about that. I mean, they had years to bring these charges. He announced, then they said, time to appoint a special counsel, and the whole operation launched into effect. 4 prosecutions, 4.5 months, all the trials they want right before the elections. It's an obvious operation, fully intending to stop Trump. But fortunately, we're seeing some pretty interesting filings here, because it feels like in many of these cases, the prosecutors bit off more than they can chew. And we'll see what the judges do with these filings as we continue to cover.